Welcome to Oregon Legal Center's video series on estate planning. I'm Richard Noble, and the topic of today's video is what is a living trust and how can it help me in my estate planning? A living trust is a substitute for a will. The way you get a living trust is you, and if you're married, your spouse, sign what's called a living trust agreement. It's a document prepared that's by us that really in many ways is like a will. It says who is going to get the property in the trust that's owned by the trust when you pass away. It's just that it uses a different mechanism than you do when you use a will. It's basically, if you look at kind of how a trust works, the people that set up the trust are called the settlors, and so if you're married, the spouses would be the settlors. The person that runs a trust is called the trustee, and in a case of a married couple, they would be co-trustees of their trust. A trustee would be the person who would sign the name on a check, sign the name on a deed to transfer property. And then the third sort of group would be the beneficiaries. And while you and your spouse are alive, you would be the beneficiaries of your trust. But then when you pass away, the beneficiaries would become the people that you named in the trust who are going to get the property when you pass away. And similarly, the trust agreement, you can't be the trustee of the trust, obviously, if you've died. So the trust agreement would provide for a successor trustee, or certain, a list of trustees who would become the successor trustee if you were, at the time of your death. And that's kind of the mechanism of how a trust works. For the trust to be effective, once you set it up, we have to put property into the trust. It has to own something, because the trust says, well, when we die, all the property in this trust is going to go to, say, our children. Well, if you don't have anything in the trust, obviously it's not going to transfer anything to them. So it's very important that property be put into the trust, and that's part of setting up a trust. We do that as when we represent you as your attorney. We fund the trust. And how property gets into the trust depends upon what type of property it is. If you have a deed, if you have real estate, for instance, the way that property would become owned by your trust would be that we prepare a deed, and you'd sign it as the owners, and you'd deed it to yourselves as trustees of your trust. Then we'd record that in the county where the property was located, and that would have the effect of making your trust the owner of your home. And we could do that for other property as well. And then with respect to like brokerage accounts, we'd prepare letters for you to give to the brokerage accounts. It would instruct them that the account you have that's in your own names should be transferred on their books, so it's owned by your trust. And so that's how assets like that would get into the trust. Now, let's talk for a minute about why people use living trusts. And there's several reasons, several very important reasons. If you've watched the video that we have on probate, you understand some of the problems you get into when you use a will as opposed to using a trust. How you get into probate, how the person you've named, you think you've made your personal representative when you signed your will, really has only been nominated by you, and has to go. That person then has to kind of be vetted by the probate judge before they get a piece of paper from the probate judge that says that they're the duly appointed personal representative of your estate. And none of these third parties like banks or title companies are going to pay any attention to the person that you've nominated until they have that paper from the court. That's what gets them into probate. When you have a trust, you don't run into that problem, because the third parties like banks and title companies, they're willing to accept the person that you've named in your trust agreement as successor trustee without any kind of paper from the court. Let's take the example that in the video on the probate, I brought up the example of your personal representative going to the bank and telling them that you died, and showing them the will, and showing them a death certificate and getting this cold reception, being told they have to come back with papers from the probate court. Well, let's just look at the same example, only this time you've got a living trust, and instead of owning an account at the bank in your own name, while you were alive, you transferred the ownership of that account to your trust. You were the trustee at that time, but now you've died, you're not the trustee anymore. Your trust agreement says that, say, your son is going to be the trustee. So your son goes to the bank and says, he shows them the trust agreement where it states that he's the successor trustee if you've died. He shows them the death certificate showing you've died. He shows them some ID, like a driver's license, that proves he's the person named in the trust agreement. And at that point, you might wonder, well, is the bank going to require something from the court to prove that he's the legally, appointed successor trustee? And the answer is they do not. They're willing just to accept him or her as the successor trustee without any kind of stamp of approval by the probate court. And what that means is that then your successor trustee doesn't have to go see the attorney to, get that paper from the court, from the probate court. He never gets into probate. And that's why he's going to get the same kind of response, say, at a title company if he wants to sell your house and get some cash to distribute to your kids. Basically, the title company is willing to play ball. They'll prepare a deed called a trustee's deed. He signs it, and they give him the money made out to the trust. He deposits the money in the trust checking account, and then he just writes checks out of the trust checking account to your kids, and that's how he distributes the proceeds of the house. Doesn't take very long to do that. Doesn't require any court approval. You're not in probate court. So that's kind of the mechanism of how it works, why you don't get into probate. Now, there's another real important reason why people use living trusts, especially as they get older. And this is, aside from just this concept of probate, having a personal representative, not having to go through probate court. And that's if you have like a disability. Say you get a stroke, or say you get Alzheimer's, and you live 5 more years. And you can't be the trustee of your trust because you're just legally incapacitated. You've got Alzheimer's. Well, the trust agreement says if that happens, then the person that you've picked to be the successor trustee, instead of becoming successor trustee when you die, that they become successor trustee early while you're still alive because you're not able to be the trustee anymore. And so you've got a built-in mechanism where somebody you trust is going to be in charge of your financial affairs if you are alive but incapacitated. Now, if you didn't have that, if you didn't have a trust, and your son realized that you've got Alzheimer's and you're not paying your bills, you can't do anything really, you don't know what's going on, what would he have to do? Well, he'd go see a lawyer at that point. The lawyer would explain to him, well, we can get some help from the probate court. We can petition the probate court to make you the conservator of your parents' estate. And basically, once you get these papers from the court that show that you're the official conservator, you can go to the bank and where mom has an account, or you could sell mom's house, and the title company would let you do that, realizing you have legal authority. But you see, if you have a trust, you don't have to go that route. You don't get into probate court, basically, because the title companies and the banks and brokerage houses are willing to accept the person you've picked as successor trustee, even if you're still alive, to manage your affairs. So basically, when you have a living trust, you don't get into probate court when you die, and you don't get into probate court if you're still alive but incapacitated. Now, the third reason why people like living trusts as opposed to wills is involves estate taxes. And there's a separate video in this series where I talk about estate taxes, and you should probably review that. I'm not going to talk about it now, but just let me say that if you do have a estate tax issue in your estate, it's much easier to deal with that when you use a living trust as opposed to a will, because you avoid probate. So I hope these comments have helped you understand why a living trust is a very useful tool in estate planning. and I look forward to meeting with you in the future.